My name is Dan Arnold. I'm the chairman of the Manassas Tea Party. I'm very honored to have you all here. I know there are a lot of people from Harrisonburg and Richmond and far-flung places like that. Colorado, wow. I didn't realize this got out that far. So we're going to get started, as we always do, with an invocation, courtesy of Mark Weaver. He's on our board at the Manassas Tea Party. Then we're going to say the Pledge of Allegiance, and then we'll get started.
For the prayer, I am going to read the first prayer offered in Congress, made on September 7th, 1774, by the Reverend Jacob Duché. Let's pray. Lord, our Heavenly Father, high and mighty King of kings and Lord of lords, who dost from thy throne behold all the dwellers on earth, and reignest with power supreme and uncontrolled over all the kingdoms, empires, and governments, look down in mercy, we beseech thee, on these our American states, who have fled to thee from the rod of the oppressor, and thrown themselves on thy gracious protection, desiring to be henceforth dependent on thee. To thee have they appealed for the righteousness of their cause. To thee do they now look up for that countenance and support which thou alone canst give. Take them, therefore, Heavenly Father, under thy nurturing care. Give them wisdom in counsel and valor in the field. Defeat the malicious designs of our cruel adversaries. Convince them of the unrighteousness of their cause. And if they persist in their sanguinary purposes of our own unerring justice sounding in their hearts, constrain them to drop the weapons of war from their unnerved hands in the day of battle. Be thou present, O God of wisdom, and direct the counsels of this honorable assembly. Enable them to settle things on the best and surest foundation, that the scene of blood may be speedily closed, that order, harmony, and peace may be effectually restored, and truth and justice, religion and piety prevail and flourish amongst thy people. Preserve the health of their bodies and vigor of their minds. Shower down on them and the millions they here represent such temporal blessings as thou seest expedient for them in this world, and crown them with everlasting glory in the world to come. All this we ask in the name and through the merits of Jesus Christ, thy Son and our Savior. Amen. Amen. Wow. Let us stand and pledge our allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The born and the unborn.
Thank you, Mark. Ladies and gentlemen, thanks again. My name is Dan Arnold. Wow, what a turnout. I'm just, I guess I shouldn't be amazed because if this doesn't speak to the love of liberty and the love of this country by so many people who've taken time out of their evening to take part in this important discussion, I don't know what does. So thank you so much to all of you for being here. Just a quick note, my phone just went off. So if you could turn off all your cell phones as we get started. I've already done so. Again, my name is Dan Arnold. I'm the chairman of the Manassas Tea Party. We are a 501c4 nonprofit. We're one of those groups that got strung out by the IRS for a couple of years. We're trying to do something about that in court right now. So this is a really important conversation. You all know that or you wouldn't be here. Should the states call a convention to propose amending the Constitution? Whichever side of that debate that you are on, I think we all can agree that we have one common problem, that our federal government is out of control. And we need a solution to do something about it. This is one of those solutions. And so there's much debate on both sides of whether it is prudent to do so, and we're going to talk about that this evening. First, arguing against the Convention of States, I'd like to introduce someone I've known for a long time, and many of you do too, Delegate Bob Marshall. Bob is currently serving a 12th term in the House of Delegates. He represents the 13th District and parts of Prince William and Loudoun counties. He's been awarded the Family Foundation of Virginia's Legislator of the Year Award. In 1999, he was the Prince William Taxpayers Alliance Friends of the Taxpayer Award. He has degrees in history, philosophy, and humanities from Belmont Abbey. College, North Carolina, and California State University. He's married to Kathy, and they've been blessed with 5 children. Could you please give a big hand to Bob? Arguing in favor of Article 5 tonight, we have Mike Farris. He's a constitutional lawyer. He is the founder of the Homeschool Legal Defense Association and Patrick Henry College. He's a prominent leader of the Convention of States Project. He shares a close friendship with Phyllis Schlafly of the Eagle Forum, and he has been involved in debates, including the one with the John Birch Society in Norman, Oklahoma, and one with Andrew Schlafly and the Eagle Forum in New Jersey. Could you please give a warm welcome to Mike Farris? And last but not least, we are very proud and thankful to have our friend Ken Cuccinelli here tonight to act as our moderator. I know you all know Ken. He was our Attorney General here in Virginia from 2010 to 2014. He was a Republican candidate for governor of Virginia in last year's gubernatorial election. And we are very regretful that he and his family are not the current occupants. Representing the 37th District in Fairfax County. He holds degrees in engineering, law, and commercial policy from UVA and GMU, and he helped launch the Virginia Self-Defense Law Firm earlier this year. He is married to his lovely bride, Tiro, and he is the proud father of 7 children. Again, Ken.
Now let's see if this will...
There's text in the back.
Yeah. All right. Should be a red light. In with the old. All right. I want to just remind you all on the cell phones. There's a lot of us in here, so please put them on vibrate or shut them off. I'm not going to call out anybody in here except one person who I haven't seen in a while, but whose importance to Virginia and well beyond Virginia has exploded in the last 9 or 10 months, and that is the clerk here in Prince William County, Michelle put her and her office on the line to defend marriage when the prospect arose that Virginia might step out of its appropriate role in defending its own Constitution. I know you were all just as shocked as I was to see the current Attorney General turn on his client. Not merely step out of the case, but actually attack his own client. Today we get to hear about a fascinating subject that has been debated previously in American history, and I'm sure you'll hear about that, from 2 folks that I have a great deal of respect for, Bob Marshall and Mike Farris. Bob, of course, being what I would say is the leading procedural expert in the Virginia General Assembly and a regular advocate of constitutional issues, and then Mike Farris, who actually literally teaches the subject, and rightfully so, and argues it all the way up to the Supreme Court. So I'm looking forward to today. The format is going to go as follows. First, the affirmative position carried by Mike Farris is going to go for 10 minutes. And then the negative position will go for 10 minutes as well. The position being, should Virginia apply for a convention under Article 5 of the Constitution for the purpose of proposing constitutional amendments that would restrain the federal government. And then round 2 We'll begin again with the affirmative position. We'll go 7 minutes, and then Delegate Marshall will have the opportunity to ask one question of Mr. Farris, and then it will switch. Delegate Marshall will have 7 minutes to address the negative position, and then Mike Farris will have the opportunity to ask a question of Bob Marshall. And then we will move to your participation. We'll probably have a brief gap, maybe a minute of time or so we can set up microphones, and as you can tell with just the screaming back microphone, we may have to juggle that a little bit, and your patience would be appreciated. I'm going to try to balance those questions to both sides. They'll both have the opportunity to address whatever question is asked, but questions are often asked more aggressively at one side than the other, so I'll try to keep that as balanced as I can. So I may call people out of order in these lines. Does anyone have a question directed to whichever one of them hasn't been getting questions, so that we can alternate and keep that a little more balanced? So that's the approach we're going to take, and we will begin now with Mike Farris.
One, two, three. I got it. Okay. Well, thank you very much. Thank you all. What a wonderful crowd for coming out tonight. Really look forward to tonight's activities. And it's not polite to edit your bio, but the most important fact in my bio was left out. I have children also. In fact, I have more children than either of them. Almost as many as both of them combined. I have 10 children and 17 grandchildren. And so yesterday I celebrated my 63rd birthday by riding my bicycle from Patrick Henry College in Purcellville to Mount Vernon, which is 64 miles. And so this is a great Virginia day, and I'm glad to carry on the Virginia tradition here tonight. I want to note that when I ran for Lieutenant Governor of Virginia in 1993, Bob Marshall made my nomination speech at the Virginia Republican Convention. So to say that we are longtime friends is an understatement. And friends can sometimes disagree. This is a rare occasion for Bob and I to disagree, but we disagree. We both disagree on principle grounds, but we're going to present to you two different viewpoints and two different scenarios and two different solutions to the problem. Dan posed the correct problem. And the correct problem is, what are we going to do about the runaway government in Washington, D.C.? And I want to just give you a little bit of data and perspective on the trouble in Washington, D.C., so that we have solutions that actually have the possibility of fixing the problems. Solutions that are general, vague, and really wouldn't solve the problems aren't solutions. So let's talk about money. According to the Center for Public Integrity, which is no conservative organization, Arianna Huffington's on their board, so just, so we know that they're not going to do us any favors by saying the truth about the federal government. According to them, their analysis of the accounting from the General Accounting Office of the federal government, I quote, based on GAO simulations by 2020, about 89 cents of every dollar of federal revenue will be spent on interest costs, Social Security, Medicare, and Medicaid. That's it. Leaving 11% of the federal budget to pay for the military and everything else that the federal government does. To think that the fiscal crisis is a problem understates it. It is a crisis of the highest level of magnitude. This country is going off a fiscal cliff. This is not an exaggeration. When Arianna Huffington recognizes it at that level, and she's not even recognizing the real national debt. The real national debt is not $17 trillion or the projected $20 trillion that these numbers are based on. The real national debt is in excess of $100 trillion when you understand that we actually owe people for the money they've invested in Social Security and so on. The amount of unfunded pensions and medical care and so on, it's in excess of $100 trillion. The crisis is even worse than I've just described to you. That is not a small issue. Then we turn to a problem with Article 1, Section 1 of the Constitution, which is the most important rule in the Constitution. The more important rule in any organization is who has the power to make the rules. Article 1, Section 1 says all legislative authority is vested in the Congress of the United States. That means all law in the country is supposed to be decided by Congress. Now, you're all familiar with the Hobby Lobby case? By the way, I'm the guy that named the bill that Hobby Lobby used to win their case. In fact, I was the chairman of the group of lawyers that wrote the Religious Freedom Restoration Act. And so I'm very proud of that victory because I worked on the issue in the early 1990s and helped get a real solution for a real problem, and that is a prior Supreme Court decision on that really tubed religious liberty. And so, but nonetheless, the problem that we see with that Hobby Lobby was litigating against was not based on Obamacare legislation. It was a regulation promulgated by the executive branch, by Health and Human Services, that said you must include abortion funding in your health care programs. That is an example of a problem that is way out of control. The Code of Federal Regulations, at least insofar as they control private people and private property, which is the vast majority of the Code of Federal Regulations, is 200 volumes. 200 volumes of laws that violate Article 1, Section 1, because the executive branch is not supposed to make any laws. Then we see treaties controlling domestic law. Bob Dole recently did a press conference attacking me for defeating the UN Convention on the Rights of the Child. Some Democrats have attacked me for defeating the UN Convention on the Rights of Persons with Disabilities, rather. I've also helped defeat the UN Convention on the Rights of the Child. They lost me at the word UN. I do not believe that treaties should control the domestic policy of the United States. And I have been the outside leader, meaning inside leaders, meaning like Mike Lee and other members of the U.S. Senate. Outside, meaning the organizations that fight against that. I have been the leader of defeating these treaties, and these people are singling me out by name because I believe that Americans should make the law for America. Yet they are misusing the Constitution of the United States to do this to us. That's a problem. Homeschool Legal Defense Association, that I still help lead, has produced 2 excellent movies on the Common Core. We got another one coming out in about a week. We are trying to defeat the Common Core, but the Common Core is a symptom, not the problem. The problem is the federal government misuses the General Welfare Clause to control the policies and powers of the states by dangling out money that they've taken from the taxpayers. They give it back to the states with strings attached so that they'll do the will of Congress. That means the legislature in Virginia doesn't do the will of the voters of the people of Virginia. That means the will of Virginia legislators doing the will of the voters in California, in Illinois, and so on, in Massachusetts. I want Virginia to control the education policy of Virginia. And the only way we're going to do that is not to defeat the Common Core only, but to defeat the federal power not only to control education, but to use the General Welfare Clause in the manner that they're using. We need to take away their power, period. The problem is not episodic. The problem is structural. The federal government over the last 200 plus years has gradually amassed powers that the federal government was never given explicitly in the Constitution of the United States. And we've got to have structural reform. Now, there are 3 responses, 3 possible responses. I want to identify people to help you remember the 3 possible responses. The people are George Mason, Dusty Springfield, and Alfred E. Newman. George Mason is the one responsible for the current form of Article 5. Because he said there's going to be a day when the federal government exceeds its authority. And when that happens, amendments that are designed to reduce the power of the federal government will never come through Congress. Ever. It won't happen. You've got to give the states the unilateral ability to amend the Constitution to make structural changes so that the federal government gets back within its constitutional authority. The second approach is Dusty Springfield. Dusty Springfield, for those of you that are my age, everybody knows Dusty Springfield. But for you younger folks, Dusty Springfield was a great singer, rock singer from the 1960s. She sang a song called Wishin' and Hopin'. And so people that think that wishing and hoping, we've been at this for a long time working on, we're going to elect more conservative candidates, so we're going to send more good Republicans to Washington, D.C. Wishing, hoping, thinking, praying ain't going to work. The definition of insanity is repeat the same stuff you've been doing and hope for different results. Anybody that thinks that sending more Republicans to Washington, D.C. is going to make structural changes is out of their ever-loving mind. Third point, Alfred E. Newman. What? Me worry? Which is basically, there is no problem or I'm giving up. One or the other. We have to have a solution that is real. Now, Article 5 is the solution, and it's very simple. Now, through the course of the evening, I'll explain the steps of Article 5. But you're going to hear two positions. Basically, they're both about fear. Bob is afraid of the plan given to us by the Founding Fathers. I am afraid of Washington, D.C. And you have to choose which one you're going to be afraid of. The Washington, D.C. is a clear and present danger. We can all see it. It is not speculative. It is not conjectural. It is not contingent. It is real, and it is coming at us like 1,000 miles an hour. And the only responsible path is to give us a solution. My time's up.
Thank you very much for coming here tonight. I hope that the accoutrements supplied to Mike and myself are not an indication of a bias, but I will call attention to the very regal podium which he received. Solid wood, and mine is this pressed board. No name on the front. No, because I am on the right. And chair. Mike, hold your chair up, please. See, that's
At least they're filled.
Since 1789, there have been roughly 700 calls for Article 5 conventions of one or the other. Most of these started in the late 19th century and carried through the 20th century, with the most recent efforts in the late 70s and 80s for a balanced budget amendment. Article 5 says the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid for all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the mode of ratification may be proposed. There's two things you can't amend: slavery before 1808 and equal representation in the Senate. Now, the position that I think my good friend, at least up till tonight, has put himself in is that the Convention of the States, while praising the founders, have boxed themselves into a position of concluding that their work product was not really good. The Constitution is the problem, even though Mike said that it's not obeying the Constitution that is seriously part of this problem. And he kind of evades or suggests that electing new officials, appointing new judges, is not the preferred way to go. Now, this kind of started off with an effort in Virginia to get a meeting in Annapolis, which did occur. Representatives, I think, from 5 states, 12 members, did eventually go to Annapolis. They decided there weren't enough people to be serious about making changes to the Articles of Confederation. 6 of the 12 commissioners were, in fact, later members of the Constitutional Convention. All of them, either at the convention or in state ratifying conventions after that, voted for the final Constitution. Now, at that time, they were saying it would take a unanimous number of states for the amendment or the change in the Articles. All of them said this, including Alexander Hamilton and Mr. Madison.
Mike Farris says in a number of publications, both their brochure, that the change in the mode of ratification from the legislatures of the states to the conventions and the number 3/4 instead of unanimous is legal in various ways. Well, that it was not a revolutionary act. I'm going to quote to you from some individuals who think it was slightly different. Now, this is Thomas Cooley, a noted constitutional commentator after whom a law school was named in western Michigan. As this was in disregard of the Articles of Confederation, which requiring the assent of every state, it was a revolutionary proceeding and could be justified only by the circumstances which had brought the Union to the brink of dissolution. Clinton Rossiter, 1787, a famous book on the Constitution, he says, their actions in the narrow sense were illegal under the terms of the Articles of Confederation. They also were, in the broad sense, legitimate under the principles of the American Revolution and were, in fact, sparked by a desire to bring it to fruition. Third one that I will cite, Charles Beard, Economic Interpretation of the Constitution, which he's modified later in his life somewhat. But he talks about the revolutionary nature of, in fact, the approval process outside the forms of law. If today the Congress of the United States should call a national convention to revise the Constitution, and such a convention should throw away the existing instruments of government entirely and submit a new frame of government to a popular referendum disregarding altogether the process of amendment now provided, we should have something analogous to the great political transformation of 1787 to 89. The revolutionary nature of the work of the Philadelphia Convention is correctly characterized by Professor John Burgess when he states that had such acts been performed by Julius or Napoleon, they would have been pronounced coups d'etats. Now, let's go perhaps to the authority on this. Now, this is the Federalist Papers, number 40. This is Madison writing this. In one particular, it is admitted that the convention had departed from the tenor of their commission. Instead of reporting a plan requiring the confirmation of all the states, as was promised by Madison from Annapolis, they've reported a plan which is to be confirmed and may be carried into effect by 9 states. Then later, in Federalist 40, he talks about an additional change. He mentions that, in fact, the ratification mode was unknown to the Articles, was unknown to the states. That being the case, what is to stop, again, if you're going by precedent, what is to stop a modern constitutional convention?
What is to stop a modern constitutional convention? Oh, okay. Well, you didn't look like you weren't listening. So. Being polite, okay, thank you. All right.
Start again.
Now, I'm going to ask this question. Does this audience trust the majority of Congress the majority of the time? No. But Mike Farris has to trust them to pull off the biggest change in the constitutional history since 1787. Mike Farris has to trust members of Congress who are so deracinated that they can't tell the front of the human body from the back. They can't distinguish between male and female, and they think two men can marry each other. Conclusion, the 1787 convention did change the mode of approval and the number of states to approve it. Therefore, a modern Article 5 convention can point to the precedents of the founders and make ratification changes not known now to the U.S. Constitution or state constitutions, or even propose voter approval by referendum. Now, is limitation of convention matter, subject matter, possible? The Annapolis Convention, in fact, declined to specify what they were going to do. Mike says there's no worry about a runaway convention. Yet in his book here from 2006, he states on page 73, there were no limits placed on the authority of the convention to make amendments. It could recommend 1 change or 1,000. Randy Barnett in the Wall Street Journal, who supported the repeal amendment a couple years ago, this is April 23rd, 2009, he said, he's at Georgetown University School, an amendments convention is feared because its scope cannot be limited in advance. The convention convened by Congress to propose amendments to the Articles produced instead an entirely different constitution under which we now live. Lawrence Lessig is also here at a talk at Harvard talking about the fact that the left and the right can get together. Now, what they're getting together about, I really don't know. The beauty of the convention is that it would provide a forum for a possibility for conservative Tea Party types who might want an amendment calling for a balanced budget, as well as progressives who would like to amend the Constitution to make it possible to enact meaningful campaign reform. The only requirement is that 2/3 of the states reply, and then begins the drama of an unscripted national convention to debate questions of fundamental law. Folks, I am going to be startled to see a horse which is going to be guided into the barn by Mike Farris on the front and George Soros on the back. Well, okay. Additionally, people such as Justice Anton Scalia, Warren Burger, moderate, Arthur Goldberg, liberal, all said a convention cannot be limited in scope. Now, this is interesting for Scalia. Secondary references indicate that Scalia, when he was at American Enterprise Institute, did support a balanced budget constitutional convention. There were 19 major changes to the Articles of Confederation. You know, you used to have to get 3/4 of the states to agree to war under the Articles, not anymore. You used to have to get their permission to coin money, 3/4, to issue bills of credit, to have a treaty or an alliance. When you met before, you were individual entities. That is no longer the case. You're not going to have one state, one vote, because we now are a united states. That is going to be the difference between what was then and what is now. The Convention of the States Council, at a debate in Yorktown, John Kelly acknowledged that everything was up for grabs except for Article 5 and Article 7. Thank you very much. Mike Farris for 7 minutes.
In understanding history, there are primary sources and secondary sources. Bob has cited to you 3 secondary sources: Thomas Cooley, Clinton Rossiter, and Charles Beard. Charles Beard is a famous leftist theorist of the Constitution, preaching economic determinism as his mode of constitutional interpretation. We are going to, and Warren Burger, the co-author of Roe versus Wade, are we really going to listen to Warren Burger? The material that you've been handed out tonight, the 2 pages, that's original sources. We're talking to you from the actual text of the actual laws. Now, what Bob is doing, he's saying that the Constitution of the United States was illegally adopted. That's like saying, and then claims to be protecting the Constitution. It really is, here's a fair analogy. It's like saying that George Washington was a great American hero, but he's also was a British spy. You got to take a choice. If the Constitution wasn't legitimate in its adoption, it's not legitimate today. I have proven to you from original sources in history that the Constitution was legitimately adopted. Madison in Federalist 40, if you read the whole thing, says that the orders for the convention were given not by Congress that Bob Marshall and his secondary sources rely upon, but by the by the state legislatures that gave their delegates their instructions and their authority. The legislature of Virginia was the first to do so. The General Assembly said to our delegates to render the federal Constitution adequate for the exigencies of the Union. And so when I wrote my constitutional textbook in 2006, I was telling you, based upon what Virginia's delegates were told by the Virginia legislature, they didn't have any limitations. They were to render the federal Constitution adequate for the exigencies of the Union. That does not mean that other delegates can disobey their instructions. The delegates were given instructions. They had to obey their instructions, and in fact, they did obey their instructions. The part that Beard and Warren Burger and even Justice Scalia gets religious freedom wrong. The reason we have to have the Hobby Lobby case is because of Employment Division versus Smith, written by Justice Scalia, that says the free exercise of religion can never be used for a person to object to a neutral law of general applicability, which means at Patrick Henry College, if we refuse to hire a homosexual homosexual teacher, and if the federal government passes a neutral law of general applicability doing so, Scalia says the First Amendment provides us with no protection. Scalia calls himself a fair weather originalist. I am a full-time originalist, and I disagree with Scalia both on religious freedom, and I disagree with Scalia on Article 5. I've studied religious freedom. I've studied Article 5. He is a wonderful constitutional generalist, but he gets stuff wrong, including religious freedom and parents' rights. He says that parents' rights are not protected in the Constitution at all. And you can read his opinion in the 2000 decision of the Supreme Court on that subject matter to prove it. So he's quoting unreliable secondary sources. Madison said, he wrote the Federalist 40 during the ratification process. It was designed to get the delegates in New York and other states, but principally New York, to ratify the Constitution. He was writing at the time when the legislatures in all 13 states had not yet acted. As of that moment, it was true what he said. But by the time the process was completed, all 13 state legislatures had approved the change in process before they sent it to ratification conventions. So if you go and read original sources, which is actually the legislative records of the 13 original states, all 13 state legislatures, if you get your time sequence right, voted in favor of the process that we used to adopt the Constitution. The Constitution was lawfully adopted, and it has been enemies of the Constitution throughout our history that have foisted off this argument that you can't trust the Constitution. What's in it for Warren Burger to say you can't trust the Constitution the way it was adopted? Because he'll think if we get distracted from the authenticity of the Constitution, we'll say, well, you can't really trust it, so therefore we don't have to worry about it. Let's just take it loosely. Let's just take a kind of this general spirit of it, rather than the actual letter. Because if you start looking at the actual letter, then it was illegal. Well, no. If you look at the actual letter rather than some historian's interpretation, who's got an axe to grind because he's communist, then you need to read the legislative records of the 13 states that I've done. Now, here's the answer to Bob's question. If they don't obey the Constitution now, why will they obey the Constitution if we change it? The answer is very simple. There are two constitutions in our country. The one that was written and the one that is being interpreted by the Supreme Court. And the one that is written, I am all in favor of, with one exception. I don't want treaties to be the highest law of the land. I think that deserves to be changed, period. And so, but other than that, I want to return to the original meaning of the Constitution on the General Welfare Clause, on the Commerce Clause, on executive power, and many other areas. But we've got to fix the Supreme Court's decisions in these areas. And so the question becomes, how do you reverse a decision of the Supreme Court? Bob can come up here and ridicule me because I think that Article 5 is a good idea. George Soros thinks it's a good idea. George Soros wants presidents to veto things he doesn't like. I want presidents to veto things I don't like. George Soros wants people like him to elect people to the U.S. Senate. I want people like me to elect people to the U.S. Senate. Just because we both agree that a political process is valid doesn't mean that our processes are working side by side. The people I'm supporting for the Senate aren't going to help George Soros. The application that I've written that has been passed by the states of Georgia, Florida, and Alaska is not going to help George Soros in one whit. I have litigated an Article 5 case in the federal courts when Congress tried to manipulate the process of the ratification of the Equal Rights Amendment. As a young lawyer in the late 1970s, I sued to stop them from manipulating the process, and I won. So those who tell us we can't stop them, Bob, I stopped them before. And I will stop them again. I am not willing to have you use ridicule and name-calling to drive fear in the people and to have them distrust the Constitution itself. Have them distrust the Constitution itself by your smattering of historical secondary sources. Let's trust the Constitution and use it.
All right, it is now, you can stay at the lectern. It is Bob's opportunity. It's Bob's opportunity to ask a question, which Mike will have 2.5 minutes to address. Bob.
The 14th Amendment was written in the blood of 600,000 plus Americans, and it was not passed to make America safe for sodomy or as a predicate for marriage. And as Justice William O. Douglas explained, the 14th Amendment was passed to give blacks first-class citizenship. Now, Which is more important when writing, interpreting, or applying a law? Original intent, actual wording itself, or the moral character and intellectual ability of a judge or legislator?
What I teach in my constitutional law class is not original intent, it's original meaning. Original intent requires you to psychoanalyze the founders and other things, and psychoanalyzing a body of legislators is a daunting task. The correct approach is original meaning, which means what did the words in question mean to the people who wrote and ratified the document, to the generation that wrote and ratified? What's the common understanding of due process of law? What's the common understanding of equal protection, and so on? And you use various sources to do that, but they must be contemporaneous with the people who wrote it. That's the correct methodology. By the way, that's the correct methodology of a lot of kinds of interpretation, including ordinary statutes, interpreting the Bible, and ordinary contracts. It's the way you interpret law faithfully, period. That's what the rule of law means. Now, is the integrity of the judge important? You better believe it's important. That's why I started Patrick Henry College and are training people so that they can get on a path to become lawyers and judges, because I want to see people who actually believe in the Constitution occupying the highest law of the land. And 5 of my former students today, right now, are on Harvard Law Review on a path to becoming credentialed to be the top lawyers so that they can become judges. I want to put so many people in the farm system that we take over the Supreme Court of the United States. I believe in long-range solutions, but I don't believe in tying people's hands like me. I litigate to defend families. I litigate to defend all kinds of people against the government. That's all I've done for almost 40 years now, late 30s and my 37 years or something like that, I've been a lawyer. And so the government is trampling on the rights of the people, and people who want to defend them have to have real ammunition. If we're going to stop the federal government from running away with the power of the people and the power of the states, we have to have changes in the General Welfare Clause, and changes in the Commerce Clause, and changes in giving us checks and balances on the Supreme Court. The Supreme Court has said 30 times that there is no realistic check on our power other than our own internal sense of self-restraint. I want to put them on term limits. Let's just start with that. Start with that. And my time's up.
Thank you both thus far for respecting the stop sign. So at this point, Delegate Marshall will have 7 minutes, after which Mike Farris will have the opportunity to ask him a question. Thank you. Mike mentioned that I quoted some secondary sources. Agreed. We, in a sense, are secondary sources commenting on all this. But I'm going to go back again to Madison, which he did not really dispute. Now, this is the end of Federalist 40. Yeah. That if they had exceeded their powers, they were not only warranted, but required as the confidential servants of their country by the circumstances in which they were placed to exercise the liberty which they both assumed, and that finally, if they had violated both their powers and their obligations in proposing a constitution, this ought nevertheless to be embraced if it be calculated to accomplish the view and happiness of the people of America. How far this character is due to the Constitution is the subject under investigation. Now, they did violate it, but the result wasn't so bad for the rest of us that time. I'm suggesting we can't count on that all the time. Moreover, you do not have the same temper of the American people that you did then. We have a circumstance where we don't have a unity of religion, we don't have a unity of culture, we don't have a unity of language, we don't have a unity of background. That was all present in 1789. That is all missing at this time right now. Now, let's go and find out, will a convention follow one vote by state? Mike says, and he's correct, in 1789, when the states were formed, they actually had a treaty. When the treaty was signed between Great Britain and the United States, it mentioned New Hampshire, Rhode Island Plantation, Massachusetts. The treaty was with 13 different sovereigns conducted on behalf or by American representatives, Benjamin Franklin, John Adams, and so on. So when they came to a convention, it would have been natural for them to say, okay, one state, one vote. But if you look at, and Ken Cuccinelli has cleverly hidden this thing from me. Okay. Oh, here it is. I found it. Thank you very much. Number one, well, I won't apologize to Ken.
This is a low end of the totem pole.
He's not my wife, so. Now, some of these people clearly did disobey their injunctions. Page 4, Max Ferrand's Records of the Convention, considered original source. On the reading of the credentials of the deputies, it was noticed that those from Delaware were prohibited from changing the article in the Confederation establishing an equality of votes among the states. I call to you the public record. All members of the Delaware delegation voted to have proportional representation in the House of Representatives. Now let me give you this. This is on May 28th. They had just met in Philadelphia a couple of days. There weren't enough members to meet to conduct with a quorum the business that they had at hand. The footnote here is written by Madison. Previous to the arrival of a majority of the states, the rule by which they ought to vote in convention had been made a subject of conversation among the members present. Now this is where you really probably should have done one vote, one state. It was pressed by Gouverneur Morris and favored by Robert Morris and others from Pennsylvania that the large states should unite in firmly refusing to the small states an equal vote as unreasonable and as enabling the small states to negative every good system of government, which must in the nature of things be founded on a violation of that equity. The members from Virginia, conceiving that such an attempt might beget fatal altercation between the large and small states, and that it would be easier to prevail on the latter, in the course of the deliberations, to give up their equality for the sake of an effective government, than on taking the field of discussion to disarm themselves of the right and thereby throw themselves on the mercy of the large states, discountenance and stifled project. I read to you, Delaware was instructed not to adopt proportional representation. They voted for it. They disobeyed their instructions. What is Harry Reid going to do? Now, if you don't think that Harry Reid can end up at this convention, I call to your attention 7 of the members of the Constitutional Convention were in fact members of Congress under the Articles of Confederation. The mode of selecting nominees to the convention at that time was the state legislatures picked them. I would suggest to you, and as in fact my nighttime reading of 1,370 pages of this hearing from 1979 suggests it's going to be otherwise. No less an authority or a conservative than Jesse Helms, Sam Ervin, Henry Hyde, all said you need to have some rule governing the operation of a convention if you're going to have it, because they were all nervous about, don't use the term runaway, unlimited, uncontrollable convention. So they proposed statutes. The American Bar Association in here was cited as saying you need to have proportional representation. You're not going to have it by states. Why? First of all, the treaty power was taken away from the states by the Constitution. They had treaty power under the Articles. That was gone. Also, Mr. Nadelson, don't know how his name is pronounced. Nadelson, okay. As incidents to the power to propose amendments, the convention may establish its own rules, elect its own officers, fix the hours of sitting, judge their credentials. If the convention wishes to alter the one state, one rule vote, it may do so. He also says in the ALEC handbook, a convention is free to change the rules of suffrage. In the ALEC handbook, page 16, the convention may change both rules. So that you're going to have votes by states, I don't think is a certainty at any time. You also have the Latin expression, expressio unis et exclusio alteris. I was a bad altar boy. Means the expression of one thing is the exclusion of other. There is only one part of the Constitution which mentions or has a requirement that the members vote as members of the state, as a unit by state. It is when the Electoral College fails to cast a majority of votes. The last time that happened was 1824. In every other instance, there is no mention as to how you vote. Article 5 doesn't delineate that. There's no mention of how you vote on the floor of the House or the Senate. But the presumption is you vote as individuals. And in fact, when they went to the Senate, they didn't vote as states. They could vote as individuals. So the fact that this would be one thing, one state, one vote, I think is not accurate. Also, Article 1, Section, 4, the Necessary Proper Clause, allows Congress to provide for, in its enumerated powers, authority to set the terms, procedures for an Article 5 convention. Senator Sam Ervin, Congressman Hyde, and others, and Jesse Helms, have done that. We have the circumstance, again, of the conclusive, or at least the preponderance of information that you would have to have proportional representation. Thank you.
All right, Mike Farris has a
Bob, what solution?
What solution do you propose for the runaway federal government that will work in a timely fashion, that will stop the excessive spending, that will stop the executive orders, that will stop the Supreme Court from assuming powers, give us real checks and balances on it? How can you take away the power of the federal government to tell the states what to do through the General Welfare Clause? What's your solution, and what's your workable plan, and what are you doing to further that solution?
Kathy, do you want to answer this? Well, I'm no dummy. On the archives building, you see a phrase, eternal vigilance is the price of liberty. I don't know who said it, but it's still chiseled in stone until Obama gets there and does something with it. So you have to have eternal vigilance, which means citizens like yourself coming to meetings like this, taking this information, sharing it with your neighbors, becoming involved in elections. Mr. Cantor is no longer a congressman. I am glad of that. Now, Eric served with me. I like him personally, but his politics was something else. Eric served with me in the House of Delegates. Right after he was elected, I met him in his office. I said, Eric, why don't you do something? Because he used to vote, for the right to life. I said, why don't you take the authority away of the courts to hear these questions? This was the right to life question, the abortion question. He said, you can't do that. I said, Eric, are you serious? He was a lawyer, trained attorney. I'm not. I just read books that my wife doesn't throw out. I said, Eric, let me go through your office. I found a book prepared by the Congressional Research Division of the Library of Congress. In there, I opened up to the Article 3 commentary. It's about a 1,400 and 1,500 page book. In the back, it lists all the Supreme Court decisions that have been overturned by subsequent Supreme Court decisions. I said, Eric, it says here, all appellate jurisdiction is subject to you. You can completely abolish the appellate jurisdiction of every federal court to hear any question, including that arising under the Constitution. It only was in 1875 or 76 that Congress passed a statute allowing constitutional questions decided in state Supreme Courts to go to federal courts. Before that, you couldn't do it. They can do that again. It also says that these appellate jurisdictions are subject to such regulations and exceptions as Congress may make. I would suggest to you that you could take the 10 constitutional amendments, although some of them would have to be significantly reworded, that Mr. Levin has. You could get 8 of those things past the statute and say, well, what good is that? You need to have statutes passed to have a marker for identifying which congressman is for you and which congressman is against you. You want us to work for 7 years to climb all these mountains for a process that doesn't produce a product. I would suggest to you, we need a product now.
Yeah. Okay, now we're going to go to your questions, and we're going to need a little bit of patience in terms of just logistically executing this, and I'm going to have to swap this mic back and forth because you all have the other. And Dan, I would just ask you, while these gentlemen are answering questions, to sort of interview your questioners so we can alternate who they're directed to. And if you all could help Dan with that process quietly, that would be appreciated. So you can start your picks. And please just say your name and go ahead and ask your question. And if it's directed to one or the other of them, we'd like to know that.
Rick Solomon here from Haymarket. My question is for Mr. Farris. The principle or the primary focus of the Convention of the States has been on this limiting the taxation balanced budget amendment. In looking at, as what I read in the Constitution, Congress has the ability to borrow as much money as it wants. It also has the ability to raise taxes. So if we pass a balanced budget amendment, fine, the accountants simply say, okay, we're going to borrow more money to make the budget balanced. There's no limitation of how much money Congress can borrow. And that has a variety of provisions to it in a lot of constitutional history. So the question is, you get what you want. You're the dog, you caught the truck. You got the balanced budget amendment. Now how do you enforce it? And how do you make it change?
I'm not advocating a balanced budget amendment standing alone. The application that we've written that is passed in the 3 states I mentioned earlier calls for fiscal restraints on the federal government, limiting the power and jurisdiction of the federal government, imposing term limits on federal officials, that would be both Congress and the courts. So we're seeking a comprehensive reduction of power of the federal government. That would be the power to tax, the power to spend, the power to borrow, and the power to regulate. All those things are on the line, and they should be done as a package, because you're right. If you just do a balanced budget amendment, there's some in the Virginia legislature that favor a balanced budget amendment without these other protections. I think we need a package that includes tax limitations. But the simple answer of how you stop this is you change the general welfare clause, because all the money, the spending that is crippling us is coming through a misinterpretation of the general welfare clause. The proper interpretation of the general welfare clause is this. If the states can spend money on this topic, the federal government is jurisdictionally precluded from spending money on that same topic. All medical programs, all welfare programs, all of the entitlement programs would be unconstitutional with that kind of wording substituting for the current general welfare clause. We can fix this, and you've got to take away their power to spend. It's not the power to borrow that's the ultimate problem, but it is a problem. Not the power to tax that's the ultimate problem. It's the power to spend that's the ultimate problem. And we've got to take away their power to spend. Bob's solution to all of this, it's eternal vigilance, yes, but what does he ask the people to do? Go elect better people to Washington, D.C. And back to, is a good idea. I've been doing that as much as anybody in this room for a long time. Just ask yourself if you think that the people in Washington, D.C., when Ronald Reagan was in charge of the White House, and when we've had Newt Gingrich in charge, when we've had other Republicans in charge, have we ever done anything to structurally change it? The answer is no. I don't trust Washington.
Just for y'all's information, each of them will have 2 minutes to answer each question, regardless of to whom it is posed. So Bob gets 2 minutes here on this as well. Thank you. You know, there are signs that say, don't walk on the grass, no trespassing, don't rob banks. These things are constantly done by people who don't want to obey it. We have a group of lawless individuals who we have allowed to be elected in office to do these things. Now, not enough of Americans are concerned about what's going on in Washington, that they see the same vision of the problems. Mike and I, there isn't, I don't think, a dime's worth of difference on what we would describe as problems in Washington. But there's a lot of difference between us on how to approach it. Although I could take, I think, 8 of Mr. Levin's amendments, put them as statutes, and work for their passage. But that's not what we're here about. He wants us to climb mountains. I don't think we've got time to climb mountains. I think it's a much more direct thing that we have to do in the near term. When you find somebody who robs a bank, you penalize them. You put them in jail. When someone is robbing the public till, you penalize them. You kick them out of office. You don't let them remain. That means you people have got to contribute to campaigns. I'll give you my name later. You got to make phone calls. You got to put bumper strips on your car. You got to put signs out in front of your house. You have to be a witness to an individual who is going to hold the line on all these things, who says there are laws, the laws of nature and nature's God, to which we must repair and we must be obedient to. I also find it interesting that no social issues were addressed in Mark Levin's book, nor are any social issues addressed as being the object of amendments from the group that Mike heads. Now, those social issues, I contend, are causing a lot of economic issues, but they're being sidestepped right here.
This next question will actually go to Delegate Marshall first. 30 seconds, please.
Would you comment on the effectiveness of term limits? My name is Dr. John Kozwinski, Manassas, Virginia.
Term limits is a process approach. If you had term limits, you might not have had Winston Churchill. To me, you need to have, look, every 2 years there's a term limit. It's called an election. And if you want to do that, you can enforce it. But to automatically do it, I don't know that that is a prudent thing to do. If there's someone who is fighting the good fight and is able to corral everybody and put them on record, and a term limit comes up, you've lost your ace in the hole at that point. So I don't know that term limits necessarily is the best way to do it.
term limits on federal judges is a great idea. And I think the idea that we appoint these people in a pragmatic sense for life has been one of the most dangerous things that we've done in this country. We need to have term limits on federal judges. The way our application is written, term limits gets to be discussed at the convention. 34 states have to agree on the agenda, and you vote one state, one vote. Bob, the Article 5 is full of one state, one vote. 34 states, one state, one vote, have to agree on for calling a convention. 34 states have to apply. Stage 2, 26 states. You've discussed something, I'm going to have to go read the footnotes. It's possible that the part that you talked about with Gouverneur Morris and so on, they were talking about the ultimate plan of representation rather than the convention itself. If they were talking about the convention itself, it didn't work out that way. That was just a discussion. Gouverneur Morris wanted something, and Virginia said no, and it wasn't adopted. It wasn't followed. And so it's always been, we've had 32 interstate conventions in the history of our republic, some of them before the Constitution, some of them after. Every single one has been one state, one vote. And so the practice has been one state, one vote. It's not written in stone, but it would be a one state, one vote process to change it. And unless the states are idiots, they won't vote for it because they'd be hanging themselves. And so the idea that term limits should be discussed as a possibility, I'm all in favor of. It would depend on how it's written, whether term limits on Congress were a good idea or not a good. But I think there's no doubt that we need term limits on federal judges, and we need to get that as soon as we possibly can. And so, Bob continues to say things I agree with. Let's get people involved. But what are we going to ask them to do? Are we going to ask them to do something that actually might work? I've been trying to elect people to Congress correctly since 1980 on a full-time basis. It's not working, folks. We got to try what the Constitution gives us.
Okay, Dan.
This question will go back to you, Mr. Farris.
Dr. Farris, Shaq Hill, lover of the Constitution, I appreciate you being here. Right now we have articles inside of Congress that have been filed for, or are ready to be filed for impeachment. When we have a president that it goes beyond the checks and balances of where he should be, and is well known by the people and well known by those like yourself and others lovers of the Constitution, the problem is we have a Speaker of the House that wants to file a lawsuit. How does changing the Constitution through an Article 5 amendment or an Article 5 Constitution of the states impact the ability to impeach and do things that we're supposed to do under the current Constitution that we're not doing right now?
I would add to the impeachment clause the provision that if the president violates the original meaning of the Constitution of the United States, that is also an impeachable offense. Clearing up any ambiguity of whether high crimes and misdemeanors include disobedience to the Constitution. And if we have that explicitly, because congressmen get into these debates about high crimes and misdemeanors and all that, does that include it? And there's a strong historical debate on that question. Why debate it? Let's say it out explicitly in precise language. Disobedience to the original meaning of the Constitution is an impeachable offense. You do that, you give yourself some ammunition. You give yourself something to do to pressure the members of Congress. And so the idea that we can pressure members of Congress to fix Washington, D.C., I tell you, it's a pipe dream. And that's what Bob is advocating. Pressuring members of Congress to reduce the appellate jurisdiction of the Supreme Court of the United States, it's not going to happen, even though they clearly have the power to do it. By the way, if they did it on abortion, all that would do would be to freeze Roe versus Wade in place, because any future case about abortion could not be reviewed by a new Supreme Court. If we work hard and get a pro-life Supreme Court in the Supreme, and they've taken away the appellate jurisdiction, Roe versus Wade is left frozen in place. So you got to understand the constitutional tools you're suggesting. Even though it's a legitimate tool, if they'd have done it before Roe versus Wade, been a great idea. Do it before they take away marriage, that'd be a great idea. Do it after, not a good idea, because what you do is you freeze the old decision in place. You're playing with tools. You need to understand how the Constitution works in practice and how the legal system works in practice. That's why having practiced this, having litigated Article 5 cases, I'm here to tell you there is no responsible solution to the mess the federal government has given us other than Article 5 of the Constitution, just like George Mason said.
That was not to you first. I caught you. First for everything. Right. It still is a first, okay. This is the American Bar Association in this hearing, Constitutional Convention Procedures. One state, one vote, I don't think is going to cut it. It said, we deem, it's page 86, we deem it of fundamental importance that delegates to a convention be elected and that representation at a convention be in conformity with the principles of representative democracy as enunciated by the one person, one vote decision of the Supreme Court. Now, you also have Hadley versus Junior College District, which the Supreme Court ruled in 1970, that one person, one vote applies to the election of all key officials who carry out major governmental functions. I would suggest to you an Article 5 convention is a major governmental function. A meeting between Maryland and Virginia on what to do about the Chesapeake Bay hardly is of the same momentousness as changing the Constitution of the United States. The 16th Amendment was approved by the states, okay? Taxes. It wasn't the amendment that was so bad, it's all the statutes that are there. You've got to have people to change the statutes in order to do something. And if you're not going to kick them out now, you're not going to kick them out later because you've given them a free pass. The 17th Amendment approved, in which the state legislatures gave away their ability to pick the Senate. How dumb was that? The 18th Amendment, prohibition, which they had to reverse a couple of years later. Folks, personnel, remember you hear the phrase, personnel is policy, or policy is personnel? We've got great structures. I have an articles of impeachment inquiry in right now on Mark Herring, because he's decided, one, he's going to attack the Constitution of Virginia. Number two, he's decided on his own that he will determine what kids pay if they are no longer being deported for now, not the assembly. He's usurping our power. You know what Bill Howell wants to do? Absolutely nothing. You know what Boehner will do with Obama and these next regulations? Absolutely nothing. You got the wrong people in power. Okay, Dan.
Mitchell Shaw, Richmond, Virginia. My question is for Michael Farris. Mr. Farris, I too am a lover of the Constitution, despite the perception that anyone who's on the other side of this issue must be an enemy of the Constitution. My question is, when I look at the clear language of the First Amendment to the Constitution, Congress shall make no law. There can't be clearer language than that. Congress has made all kinds of laws abridging religious freedom, freedom of speech, and on and on. What magic language are we going to write these new amendments in that will somehow oblige the same body that's ignoring them now to abide them then?
Yeah.
The Supreme Court obeys the amendments that have been recently passed with without exception, with no material exceptions. What happens is, over the course of time, those decisions erode. And if you write it clearly, you don't give them wiggle room. The Commerce Clause was not intended to give the power to regulate anything about money. It was to regulate shipping. And if you rephrase the Commerce Clause to say Congress has the power to regulate interstate shipping and not anything that's economic in character, you can write things so simply that even the Supreme Court can't get away with it. And if you put checks and balances on the Supreme Court, put term limits, put the ability for the states to reverse the Supreme Court, to remove the Supreme Court, then you've got something to do. We're talking about a system as if we have no ability to put limits on the Supreme Court. I don't want to play that game anymore. I want to play the game where there are limits on the Supreme Court of the United States, and the only way we're going to get limits on the Supreme Court of the United States is through Article 5. It can be done, and if we're going to save the Republic, it must be done. Electing, Bob says the people of America today don't have the character to elect the right kind of people. But what is the solution? The people of today need to elect new people. Well, it's the same people both ways. The reality is, I trust the American people if they're given realistic plans for realistic choices and actual solutions. Just more of the, let's get out and vote, let's give the politicians more money, and all of that you've heard tonight. And Bob is one of the most, full of integrity guys that I know. I'm not saying he's doing this for money. He really is a principled guy. But his solution is, help elect the right kind of people. Give them more money. Go walk the doors. That's a good idea. But it has not worked, and it's not going to work unless we have structural changes.
Tonight, when my wife and I were driving over here, we were listening to Mark Levin. And he was talking about people who don't reverence the Constitution. But if you reverence the Constitution, why do you want to change it? It's like saying to your wife, I love you, honey, but we need to do some modifications with you right here. I don't think that is the way to do it. We need to have you already have a structure right there that is very adequate. We don't have people adequate to the job of pulling us over the finish line. You have got to, I said, you go to your neighbors. I didn't say everybody is corrupt. You got to go to your neighbors. You have to explain to them the benefits of the conservative vision that we have. You cannot keep it to yourself. You don't put your light under a bushel. You let it shine. You share this with other people. You do go door to create neighborhoods. Back in the 20s and 30s, before there was a federal government, the churches did most of this. They pulled away, and then the feds stepped in. Yep. We have a situation right now where states are just as bad as the federal government. Yes. Common Core, there's only about 6 states that haven't accepted. Medicaid expansion, I have this if you want to take it, these packets. And I know married people don't talk to each other, but I don't have enough for everybody here. So we have 100 of these. So if the wife takes it, please, husband, don't take it. So, look, you can talk about the gross spending per capita. In Republican states, it's just as high, if not higher, than other states. We are not true to our word. You've got members of Congress who sign off on the Republican platform, which Mike and Phyllis Schlafly worked on, and then ignore it once they're in there. That is our responsibility to hold their feet to the fire. Government is not something that runs on autopilot. Eternal vigilance is the price of liberty.
Bob will be issuing other free marital advice after. Dan, where are you? Back left corner, okay.
Stephen Hollingshead, Leesburg. I'd like to thank both of you gentlemen for a very spirited interest. I think there's a lot that we all agree on, and first of all, both methods of amending the Constitution are Article 5 methods, right? But there's sort of one fundamental difference. Well, there's also one thing that they share. If we're going to get it done either way, and I do favor some amendments to the Constitution. Most of them are removing prior amendments to the Constitution. But if either way we're going to do it, it's got to be pushed by the force of public opinion. You have to rally public opinion to do it. The reason, I think, if you look at Article 5, why have we always used one method to amend the Constitution, is that you can give people an advance, you can rally people around the content. We're just going to repeal the 17th Amendment or the 16th Amendment, right? You say exactly what you're going to do. There's a pig and a poke problem here. If you have a convention, you have to trust that they're going to come up with language that then later you can support. So I think that's maybe the biggest obstacle. What's your answer, Dr. Farris?
The answer is there's a structural thing that makes a huge difference, because the process that you're talking about is 2/3 of both houses of Congress. 2/3 both houses of Congress. That is an absolutely impossible task for any amendment that would reduce the power of Washington, D.C. You can't propose one that will ever get through that process. A simple majority vote in 34 states to propose a convention, a simple majority vote of 26 states within the convention, a simple majority vote of 38 states is possible. Very daunting, but it is possible. And you're right on one thing, and that's this. Without rallying public opinion, this isn't going to happen. But that's what we're trying to do. Now, I've been told before that it wasn't possible. When I started Homeschool Legal Defense Association, we were facing the teachers union and the education establishment. Everybody knows the teachers union is always either the most powerful or one of the most powerful groups in every state legislature. And by rallying the support of a dedicated minority of people, state by state by state, we won that battle in all 50 states. I have seen the people do the impossible, and I've seen God do the impossible. I am not afraid of trying new things. I mean, a guy that starts college, a guy that changes the law on homeschooling nationwide. I have seen God deliver the impossible through the power of the people, and I'm not afraid of the people. I'm not afraid of the liberals. I'm not afraid of Harry Reid. I'm not afraid of George Soros. At the Virginia Ratification Convention, one of the leading delegates pro-Constitution said, "An enlightened people will never suffer that which is intended for the liberty to become an instrument of tyranny." That means the people, if they know what's going on, will stop the process. Article 5 is our method of stopping the federal government.
In Virginia, it simply takes a majority vote to approve or to reject if an amendment goes to the legislature. Other states have higher thresholds. I'm not certain that they're all majorities. Okay. The fact is that we have to have responsible officials to respond to us. If you never get to that point, and all you want to do is have a call for a convention, which Mike's group has three broad classifications, you don't have any specificity. You really don't know until the end of the process what the language is. So you're asking me to work for 7 years, maybe, and it took, I don't know how many years to get the balanced budget up to 33 votes. Now, some people claim that we're over that right now with the passage in Michigan and Wisconsin this year. And a member of Congress asked Boehner, in fact, are we at that threshold? I don't know if we are. They're going to try to figure that out. We have to have citizens who are alert. Again, government is not something on autopilot. There are reasons why we have record votes, so you can see what's going on. You know what Bill Howell tried to do in Richmond? He changed the rules to say that there would be no record votes in subcommittee. You know the only Republican who voted against it? Me. Mark Berg wasn't there at the time. Now, you have to have sticks in the mud down there. It is costly to do this. Okay? He, in fact, gave me a district that Barack Obama won with about 55%. No other Republican has a district like that. I need people like you to help me win. Others who are conservatives, who are convicted of the benefit of the Constitution and the usefulness of it, need you to win. You cannot contain this Goliath in Washington simply by pushing for a process that you don't know the outcome in the end. Besides, you're asking the same people who disobey the process, who disobey the outcome, to help you in the end. It doesn't make sense.
Question for Bob.
Question for Bob Marshall.
Yep, we've gone 4-1 and directed at Mike here.
Mike Stern, Fairfax Station. Delegate Marshall, I've heard your position and I greatly respect it, but I'm trying to understand. Do you believe that when George Mason proposed, when he insisted actually on the Article 5 Convention as a protection, a necessary protection against the encroachments of the federal government, which he was sure would happen in 1786, he was convinced that the federal government would in fact grow too powerful unless there was a check on it, and he insisted on the Article 5 Convention to be in the Constitution. Do you think that was just a mistake? Is that your view?
Actually, on August 6th, the Committee of Detail proposed a number of amendments, one of which was to have an amendment process in the Constitution which provided for the following. Only the states could propose amendments to the Constitution. They would propose amendments to Congress for the calling of a convention. Several days went by. Madison had a solution. You know what his solution was? To have Congress propose the amendments to the states for ratification. So while Mason may have done that, the Committee of Detail took his idea, state only, and that was rejected in the final passage. So to have that case, I'm suggesting to you, the way is just exactly reversed. Moreover, the 33 amendments have been sent to the states. I think 27 have been adopted. One was out there for 200 years. We don't know, well, 203 years. We don't know how long these calls are going to be good for. Who has to decide that? The Congress. The Congress has added conditions to Article 5, such as the requirement that an amendment be ratified in 7 years. They tried to do something which was stupid, and my wife and I worked for Congressman Dornan. They voted to extend the ERA, mind you, for the same number of months that Antichrist was to rule in Jerusalem. And, well, it's true. It's true. We made this point in the office. Mike was on the case to kill that in the long run. So they find ways around everything. And that 27th Amendment, which says you can't have a pay raise, you know what they've done? They've gotten around that by having cost of living increases. These people are perfect, subtle hypocrites and Pharisees 28 to 75% of the time. If you're looking at them, they're 28. If you're not looking, they're 78% of the time. You need to have an alert citizenry at all times to do this. There is no substitute for you for self-government. Nobody else can be involved in self-government except you.
The founders thought they were giving us a government of laws, not a government of man. Both are important, but ultimately one controls. Bob's entire theme tonight is a government of men. He says, replace the men, you get the right government. I believe that the heart of every man is wicked and despicable. Who can know it? You know, the heart, all have sinned and fall short of the glory of God. The wages of sin is death. The founders believed those things about the heart of man, and they gave us structure to rein in the heart of man. Checks, balances, federalism. And the reason, you know, his answer on Article 5, Bob, I've understood everything you said. But what you said about George Mason just was runaround. It wasn't a direct answer. What was proposed, what was talked about is not the question that was asked. The question is the Constitution that was adopted, what, do you think that was a mistake? You didn't answer the question. Now, but his arguments tonight are this, that it was a mistake. It's dangerous. We don't know what's going to happen. And sure, we don't know the jots and the tittles, but we do know the big pieces. And we have to use it. It's the only structural choice. Because what are you going to ask these legislators that we elect to do? I've done as much as anybody, and I mean this, anybody in the room for electing right people. The Gen J teams that I send out to elect constitutional conservatives, every election have done more door knocking than, I guarantee you, than everybody in this room combined. And we have first-rate political activists. I don't believe in turning away from engaging in the political process, and I've got a long-time track record to prove it. But I'm here to tell you that unless you have an actual plan you're going to implement at the end of all that, what do you want the legislator to vote for? You know, are you going to be for good government? Are you going to be for the Constitution? Not specific enough for me. I want a real plan. Bob's giving us platitudes. I'm giving you a plan.
Dan, two more. Okay. To Bob.
Did you have a question for Delegate Marshall? Yeah. My Phil Donahue here.
Hi, my name is Melissa. I have a question for Bob. You said that the people need to be more involved, and I agree with that in getting out the word on the things that are important to us so that we can vote for responsible congressmen, senators. But here's the thing. There are a lot of people who don't even pay attention to what's going on in the world right now. They're not in touch. And when we have states, the people who are voting on things in the state, and a federal judge is overturning those things within the state, there really has to be something that we can do as the people. So my question to you is, why can't we come together as a body? You and Mike have a history. Why can't we come together and yes, get the word out there for people to come and vote and get the issues out there on the issues that are the things that are important to us. And be involved in the process of the Convention of the States to make a difference now. I have 4 children, and I see our rights as individuals being stepped on more and more and more. And it concerns me. And so I think that we need to just come together. And I'm questioning you, because you do have this history and you do have this position. Why isn't it possible to do both?
To me, it is much easier to try to pass a statute. If you don't get a member of Congress to introduce it or to co-patron it, you beat them. You go after them the next time relentlessly, and you get more people to do it. Look, when this judge, whatever her, I can't think of her name, in Norfolk, decided the decision, striking down the Marshall Newman Amendment, named after me because I was the one who worked on it. Mike had some help with the origin of it as well. But she said, in the words of the Constitution, all men are created equal. My 2 boys called me up at 11 at night and said, you won't believe what this federal judge just said. And I said, what's that? They pointed it out to me. This woman gets $180,000 a year to do this. Now, I issued a call that said this woman ought to be impeached. But impeachment is a very high threshold. And even though it was given to us by the founders, it is very difficult to use. The first time it was used was against Justice Chase. And in fact, Albert Beveridge, who wrote the 4-volume life of John Marshall, said Marshall's response was, rather than impeach us, just take our appellate jurisdiction away so we don't get into these areas in the first place. But when I sent an email out around the state of Virginia saying you need to call your own congressman and tell them about this impeachment, but you need to call the gentleman from the 6th District, who is chairman of the Judiciary Committee from, where's he from? Bob Goodlatte from Roanoke. I had a lady call me up from Hampton. She said, I talked to my local congressman, but when I called Goodlatte up, his phones had a message. We're not accepting any more messages. You all melted it down, but he didn't do anything. Someone has to jack Bob Goodlatte up and say, hey, you got the power, now use it, and threaten this judge because she's so stupid, she can't even walk, she shouldn't be allowed to walk the streets unescorted if she can't tell the difference between the Declaration and the Constitution, which a 6th grader can do. She's making decisions over us, for us. Devastating.
I'm sorry, that would break the format. And we're not going to do that with 1 question to go. Mike.
Filing bills isn't passing bills. If we're going to get something done, we've got to have a process that has a possibility. I don't want to impeach one federal judge. I want to take away the power of all the federal judges to be there for life, the power of the federal judges to interpret the Constitution however they want. You can have real checks and balances on the federal judiciary by properly drafted amendments. We can do it. That's what George Mason said. He said there's going to be a day when this government exceeds its written authority. And what was the solution that he believed in? Change the written instructions to make it clear to them. You have to say the general welfare of the United States wasn't the best way to rein in federal spending. It's what it was intended to do, but it sounds pretty broad. Commerce Clause sounds pretty broad. There's more precise ways we can write those things. We can fix many of these problems, and what we've done by this is validate the process that gives the states the ultimate authority over making sure that the federal government doesn't run away with it. Bob, you were elected by the people of Virginia to exercise all the duties the Constitution gives you. The Constitution gives you a duty under Article 5 to rein in the federal government because it gives you the power to rein in the federal government. You're saying that you and your colleagues in Virginia shouldn't use the power that the Constitution gives you to rein in the federal government. You can propose the agenda for the amendment, you can send the delegates to the convention, and you can decide if they're going to be ratified or not, because nothing gets ratified unless 38 states approve. Unless 38 states approve. The idea that something crazy is going to happen to us when 38 states have to approve requires us all to take leave of our political senses. Now, maybe it's going to be too hard to get everything we want done, but nothing will be done if we try to do nothing. And Bob is advocating the same old, same old.
Okay, last question, Dan.
Directed to Bob Marshall.
Either.
Okay.
That would be a
And
yes.
I would consider this kind of your closing statements, so feel free to make it rousing, as if it hasn't been already.
All right, well then wait a minute. Okay, so then answer the question, and then, yeah, you have 2 minutes. No. Not on this one. Oh. Look at that.
Well, you decide when we ask.
Yes, all right, whoa. So this is same format, 2 minutes, first to Bob.
Okay. We've got a lot of lawlessness in this administration, in the Congress. Rather than adding an amendment to the Constitution that could cause us to possibly even lose our Constitution, why can't we do, because Mr. Farris has some wonderful ideas, why can't we do what was done with the other amendments that were added to the Constitution? Why does it have to be a constitutional convention involving all 50 states and also possibly losing our Constitution? Look, if you go online, you will see lots of constitutions waiting to be replacing our current Constitution. Do we want to take that risk? Can we not do the amendments, add them like the Prohibition one, without getting together for, look, there are too few people I trust right now in Congress and including Virginia or any of the states that would represent my beliefs in it as a delegate for them going to a convention. I don't trust them. And I think that we're living in a ruthless age where people are paid off. Let's do the amendments like the others were done. Let's do not do a constitutional convention.
Okay. This right here is called the Second Constitutional Convention, put together, I think, by law professor Richard Labernsky down in Kentucky. Do you know what he wants to do with the Second Amendment? He doesn't want you to have the Second Amendment. So, this is another book right here. Do we need a constitutional convention? Making all kind of proposals. The Ford Foundation, the Rockefeller people, they got the money. They're going to be calling the shots on who's a delegate and who's not. Here's another one right here, a second constitutional convention. Are we going to rely on a structure when Mike says the only part of the current structure he doesn't like is the part about treaties, and that may just be an interpretation that is out there. I would suggest that you could pass a statute to tell the Supreme Court to use words in a certain way and not use them in another way. We routinely do that in legislatures, that you have to use a word in the following fashion and no other fashion. This is constantly done. I don't think you need to change everything to get something of what you want. You need to have a track record. The Hyde Amendment was devised when I walk up to Bob Bauman, a Southern Maryland congressman, gave him an idea, said you need to have a record vote to get some congressmen out of here. He said, I got just the guy to give it to. Turns out to be Henry Hyde. That started a fight because we had a marker for taking a position. If you let these people go away without taking positions, you will never get rid of them because you don't know what they really think or what they'll do under pressure. You have to have votes that mark out what they're really going to do under pressure. The only way to do that is to get bills out of committee, is to amend bills on the floor. You have to get record votes. If you don't do that, you can have Judases all the way through here, and they won't do anything by the time you get this thing to a constitutional convention. It is rapider to be done. It is more certain to get votes so you can understand intelligibly what's going on to try a statute. If you don't pass the first time, try it a second time.
Mike, 2 minutes.
Bob didn't answer your question. I'll answer your question. The question is, why couldn't you use the same process that's given us the 27 amendments previously? The answer is, how did we get those 27 amendments? We got them when 2/3 of both houses of Congress proposed the language. You've got to have 67 members of the Senate and 290 members of the House vote in favor of reducing the spending authority of the federal government. You've got to have 67 senators and 290 members of the House voting to take away their ability to regulate through the Commerce Clause. You've got to have 67 members of the Senate and 297 members of the House imposing term limits on themselves or term limits on federal judges. There is no no political theory or practical plan in place that will ever accomplish any of those things. So the idea of amending the Constitution through the other way is impossible because Congress, as George Mason told us, Congress will never reduce the power of Congress. And since the 11th Amendment, it has never been done. The 11th Amendment, the Constitution was brand new still. States still had the 17th Amendment, hadn't come along yet. States still had power. Other than the 11th Amendment, they've never reduced the power of the federal government, and even that was reducing the power of the federal courts, not Congress. Congress will not reduce its own power. And so the question is, are we going to put up with a federal government that has no structural restrictions? In the Obamacare case, Chief Justice Roberts, a great Republican example of work hard and elect people, and then we'll get the right people in place. Chief Justice Roberts said, there is no constitutional limitation on the power of Congress to tax and spend. I don't want to live in a country where there's no constitutional limitation on the power of Congress to tax and spend. We can change that. We can fix that. George Mason believed in structure. The founders believed in structure. Madison believed in structure. Why did they think we didn't need the Bill of Rights? Because they believed in structure, and I'll answer more later. I got the stop sign.
All right, the last two sections, we will alternate 4 minutes each, twice, starting with Bob Marshall.
Folks, again, thank you for coming here tonight. But Mike has said, while he likes the Constitution except for one part of it, he wants to change it. That seems inconsistent to me because he's going to rely upon people who he says will not give up power to propose a process to give up power. That is a contradiction. The only way you're going to get around that is to get people who really don't want to stay there a long time and say, I'm going in here and going out. Now, you could try a statute which says, if you're here longer than 12 years, if you want to do the term limits, your retirement goes down 20% per year. Well, that would not be illegal because you're not reducing the pay of a federal official while they're in office. If you want to control the courts, do what Jefferson did. He completely abolished an entire level of federal courts. You don't need to have the current structure to continue. Remember, 1875 was the first time that cases could go from the state Supreme Court on a constitutional question to the federal courts. The state courts are required to uphold the Constitution. Those people are easier to deal with. Why? Because we get to appoint them in Virginia and can pull them back. Now, is it perfect? No. Why? Because our Republican leadership about 1.5 years ago decided they want to be modern. They don't want to show that they're intolerant. We nominated, now I oppose this, an individual who thinks he's a guy, who thinks he's married to a guy who identified Mr. Cuccinelli as walking on the backs of all the homosexuals in Virginia, who said that every judge in Virginia was biased against homosexual, who had sperm donor kids, and is out here walking and parading around, as he has a right to do it. I didn't want to appoint someone with such an activist background to be a judge in Virginia. Republican leadership did. We did that. Now, how many of you know what your delegate did? You need to find out who voted for that individual and say, you know what? I don't think that was very prudent. It is a judgment call. Yes, I'm required to obey the Constitution, and I'm required to exercise my judgment in accordance with dictates of prudence as to how I do it. Now, what have I done? 3 statutes I got the John Birch Society and the ACLU to support me. I got the law, and Ken did this also in the Senate, the statute which says if the federal government is telling the Virginia Department of Motor Vehicles to change the license plates such that we can't be sure of the information on it, we're not going to comply. Secondly, I wrote the law, the anti-NDAA law, which says Virginia will not collaborate when the federal government or the Department of Defense takes you off the street without a trial, without legal counsel, without specific charges. That was my response. We don't have to participate in these abrogations of prudence and constitutional propriety that Washington wants to engage in. We don't have to do it. Now, Virginia, I think, is the only state that's done it, or one of 2 states. I introduced that. Those were against the federal government, against our own over-invasion of our own right to privacy, not the Griswold kind, but the right to be free of unreasonable search and seizure. This year, I got a statute passed which says the police are going to have to get a warrant before they go to Verizon or any cell phone company to track you. Now, those are things that I have done to curb overreaching power of government at the state and federal level. You can get other people to do the same thing. You need to repeal the NDAA law at the federal level. There are any number of things that can be done by statute. I'm talking about something that is practical, that can be done, that'll happen in your lifetime. It took 203 years to pass one of those amendments. You can't wait that long.
Dr. Farris, 4 minutes.
Bob says that I support a process that requires Congress to approve the procedures. No, I don't. I haven't said any such thing all night long. Congress has no power to name the rules. He read you from Rob Natelson. Rob Natelson is a constitutional law professor retired from the University of Montana, who has published more articles on Article 5 than any other person in history. He is the expert on Article 5. The conservative group, ALEC, has him as their expert. He's addressing the Federalist Society as their expert in a meeting that's happening early next month. Rob Natelson has done the research, and it shows the delegate, and Bob read it to you, the delegates at the convention from the states passed the rules. There are state legislators right now drafting rules. The rules will be advanced by the people that are prepared. There are conservative people right now advancing the rules. We have conservative Virginia Republicans helping to write the rules. We're working on a draft, but they won't be final until we get to the convention. We can do this. We can do it successfully. We don't have to be afraid of our shadows. We don't have to say that the only solution to our problems is go out and elect more conservatives. Because we've been trying to do that for a long time. And we're asking, people are getting disillusioned because we say, well, if we just elect more people like Bob and Ken, who I help both, and will continue to help them whenever they run for office. If they're running for something that I agree with them on. Bob, if he's running for something relative to the Article 5, maybe not. But nonetheless, in general terms, I am going to help conservatives no matter what office they're running for, because I want to see conservatives elected. But it's not solving the problem. You've got to say, what are they going to vote for when they get there? And there is no solution that Bob's given to any overreach of the federal government on the broad scale. What are we going to do about the federal judge in Virginia? He can't impeach her. The state legislature can't impeach her. Congress has to impeach her. You cannot remedy the vast majority of things that he's saying we can remedy in Congress through statutes in the states. So you're going to have to radically change Congress, which goes against common sense. Common sense and 200 years of history, and if you just take the history from Ronald Reagan till now and say, have the Republicans ever been in control? Yes. Have we thought the conservatives were in control? Yes. Well, I mean, okay. I mean, we thought that. Whether we were accurate or not, maybe not. But at least we thought that. We worked hard. We celebrated. Ronald Reagan, the greatest president of my lifetime, couldn't deliver getting rid of the Federal Department of Education. Washington, D.C. controls the process. If you want to trust Washington, D.C., let's keep working to improve Washington, D.C., because that's Bob's message. Let's improve Washington, D.C. by sending more consistent conservatives there. I believe in sending more conservatives there. I have a track record of helping to send more conservatives there. I've raised well over $1 million to help send more conservatives there. I've helped and organized people to knock on hundreds of thousands of doors to send more people there. It's not going to solve it, folks. Bob has told you nothing tonight other than let's just kind of do more of the same thing. Wishing, hoping, thinking, praying. It's not working. It's not working. It's time to stop believing that more of the same will work. We can do it. The founders expected us to do it. If the founders were able to come back right now and they'd say, how in the world have you let the federal government get away with this nonsense? Why didn't you use Article 5?
This is the closing 4 minutes for each of them. Closing 4 minutes for each of them. We'll start with Bob.
Article 3 of the Federal Constitution, Section 2, Paragraph 2 reads, talks about original jurisdiction of the Supreme Court. It says, in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Now, Congress, I said, can abolish their appellate jurisdiction. Congressman Sensenbrenner did have a bill a number of years ago attempting to do this with federal courts. I suggest to you they should try a statute which says we're going to override decisions that we don't like on a 2/3 vote. It's an exception and a regulation that we're making as provided for in Article 3. And the ACLU is going to go through the roof and say we don't like it? Tough. Push it anyway. Now, as to the claim that you're going to have one state, one vote, I don't think it certainly is not uncontested. It's not written in stone anywhere. Sam Ervin, no constitutional slouch, had a bill passed the Senate twice which said we have a way to provide for an orderly calling of a constitutional convention. Henry Hyde, who led the impeachment proceedings against Bill Clinton, introduced the same bill. Jesse Helms, who certainly would have to be considered a lover of the Constitution by everybody in here, introduced the same bill to suggest that it is written in stone, that it comes down from the sky, that you're going to have one state, one vote, I suggest is not the case. There's 1,370 pages in here disputing the claims of Mike that they've got this thing down and there's no questions. There are constant questions. For example, how does Congress count a call from a state which says they want a specific balanced budget amendment, to take an example, versus a call which says we'd like a limitation on spending? They're going to have to count this. They're going to have to make up rules to decide how to do this. None of this is spelled out at the present time. How are they going to make these decisions? All these are questions that need to be answered, which are not answered right now with any law. Right now, there's no statute in Virginia that would deal with ratification by an amendment if there were a convention. You know what happened back in 1933? The Assembly passed a statute. Oh, and this was cute. The Congress figured out that the state legislatures were controlled by the temperance people and probably would not ratify a repeal of prohibition. So what they said is, and this is the first time, you're going to have states ratify by conventions. 7 states in 1933 refused to pass a law to provide for a convention. You ultimately had about, I think, 42 states pass laws. More than half of them said, if the federal government is going to provide for a regular way of choosing delegates to these conventions, we'll abide by it. New Mexico said, no way, no how, any such law is null and void. The other states were just quiet about this thing. So they were all over the ballpark. In Virginia, you know how it was done? The statute was passed in August of 1933, which says there's going to be a convention and a vote on October 3rd. The governor, the speaker, and the lieutenant governor were a committee to which the political parties submitted names of people to attend the convention. So your name would appear on the ballot as pro-repeal or against repeal. Now, do you want Bill Howe, the lieutenant governor, and Terry McAuliffe saying who's going to attend a ratifying convention? I don't, but that's the only law that we have in Virginia, or that we had in Virginia, to ratify that. There are too many uncertainties to give me any confidence. I know Mike's got the confidence, but I don't. And these are questions of prudence and judgment and experience. And on that, we differ. On the principles of the common good, on the right to life, on marriage, we're the same. But this is a question which requires other considerations. Thank you.
That's correct.
In 2020, 11% of the federal budget will be available for national defense and everything else that the federal government does. Entitlement programs and the national debt, all of which violate the original meaning of the Constitution are going to crush our country. Bob's solution is, let's go knock on doors, let's go keep doing what we've been doing for a long time. Ladies and gentlemen, there is no plan. Reducing the jurisdiction of the Supreme Court in certain cases would be a good idea, but you got to get it through Congress. It's not going to pass through Congress. There's a functional collusion in Washington, D.C. Washington, D.C. believes in one thing above all things, and that is the power of Washington, D.C. They want to preserve the power of Washington, D.C. We've heard nothing. By the way, if you want answers, I mean, Bob has thrown so many particular things, and just because of the rules and the time and the need to answer the big picture, I haven't answered every single jot and tittle of this thing along the time. But if you want to go to our website, conventionofstates.com, we've got answers to everything he said tonight, and written by top experts who really do know the Article 5 process. If you want to dig in, if you want to investigate it, go to the website and read the sources. You'll be satisfied with the answers. But let's just focus on the big picture here. I have 10 children and 17 grandchildren. Right now, why are people not participating at the level that we want them to participate? One of the reasons is the frustration that was represented by the marriage question, that all three of us worked really hard on. We were a team and we worked really hard on that. I helped write the language. Bob pushed the language through, Ken defended. You know, we were a team. Now, the reason people are frustrated is the federal courts, frankly, they decided that a long time ago in a prior decision on sodomy. Justice Scalia said in his dissent, if you don't know that they've just legalized same-sex marriage, you don't know how to read Supreme Court decisions. I'm paraphrasing, but that's essentially what he said. These lower federal court judges aren't making this stuff up. They are following what the Supreme Court has already done. And we should have been impeaching, if we're going to impeach somebody and file articles of impeachment, it should have been done a long time ago. Why do the Republicans not want to do it? They know they don't have the votes to get it done. Are there times they wish they would? Yeah. Bob Goodlatte's a good guy. He wishes he could get it done. But he's not going to do something that he knows that is utterly politically impossible to accomplish. We have good people there that know it's utterly politically impossible to do this. Now, he brings up Henry Hyde and Sam Erwin. Sam Erwin wrote me a personal letter thanking me for my work on the ERA case. So he's a great man. I treasure that letter in my heart. But the reality is, failed bills in Congress set no precedent. And Bob is relying on failed bills in Congress. What sets precedent are actual practices for 400 years, 200 years, 100 years. Actual precedent is either court decisions as we follow them today, we shouldn't be, but that's what we do, and legislative precedent over time. The actual precedent in place is one state, one vote. We have the means in the Constitution. The founders thought we need to give the states structural ability to change the rules when the Supreme Court gets out of hand, when Congress gets out of hand, when the White House gets out of hand. Ladies and gentlemen, they're out of hand. And asking those same people, maybe I don't trust the Republicans in all the states' legislatures combined as much as I'd want to, but I trust the states on the issue of how much federal power we should have more than I trust Congress on how much federal power we should have. And that's the question we need to ask. Ladies and gentlemen, please help me do this.
Thank you all very much. If I could have a joint round of applause for the two debaters here.
And also a big round of applause for the moderator tonight.
I just want to remind you all how unusual your just participating by coming here and thinking through all of this is. You all are in the tail end of the bell curve, and I know Bob and Mike agree with me that we appreciate your interest, whichever side you may be on or not on either side at this point, that you're this engaged. And I also want to thank the community college here for hosting us and the Manassas Tea Party for putting this event together. Dan, Jen Basinger, who is 37 weeks pregnant and therefore not here. Keep her in your
Deborah Weber,
prayers.
who did a lot of the heavy lifting along with Rita Dunaway from Convention of States. Thank them both as well.
Thank you all for coming.